In this module, as part of the Church HR Toolkit, we'll cover dismissals on the basis of statutory restrictions, some other substantial reason, SOSR, as well as settlement agreements and without prejudice conversations. As well as dismissal on the grounds of conduct, capability and redundancy, covered in Module 6, Performance Management, and Module 8, Change Management, there are two further routes for dismissal. These are statutory restrictions, such as disqualification from driving, where driving is an essential part of the role, and some other substantial reason, SOSR. For instance, if an employee's behaviour causes significant reputational risk to the organisation. Another route would be a settlement agreement, which is a legally binding contract between an employer and an employee that outlines the terms and conditions under which the employee will leave the company. Sometimes an employee may be dismissed due to statutory restrictions, also known as statutory ban. This happens when legal reasons prevent the employee from continuing their job. For example, if an employee works with children or vulnerable adults and has a related offence on their DBS check, they may be legally barred from their role. Another example is if a person loses the right to work in the UK due to an expired visa. These dismissals are based on legal requirements, not performance. If a statutory restriction is discovered, the employee should be suspended immediately, pending an investigation, which may lead to a formal meeting to discuss dismissal. You should keep up to date with mandatory checks and legal compliance to prevent situations where an employee needs to be dismissed due to a statutory restriction. This may include regular checks of visa, driving licence, DBS or professional qualifications. Another dismissal route, known as some other substantial reason, SOSR, may be applied in rare cases, typically where there has been a breakdown in trust that is not related to conduct. For instance, where an employee has caused such significant reputational damage to the company that their position becomes untenable. It is essential to be clear on the reason for dismissal, as this will be scrutinised heavily by a tribunal, so justifying dismissal under SOSR can be challenging. Employees must always be reminded that they have the right to appeal and to be accompanied at any formal meetings. A settlement agreement is a legally binding document that ends employment, typically including a reference and an agreed financial settlement. This document ensures the employee cannot raise a future claim against the PCC to a tribunal. You are likely to need the advice of a solicitor, so please refer to the HR team for assistance with a settlement agreement template. To commence a without prejudice or protected conversation, there must be an ongoing formal dispute, such as a grievance, capability issue, or redundancy. The benefit to the employer is that the contents of these off-the-record discussions cannot be used as evidence in unfair dismissal claims, including constructive dismissal. All parties must clearly understand its meaning, and all communications must explicitly state without prejudice, and include this in the subject heading. These conversations should have legal or HR presence and require a legal advisor to complete part of the agreement. If initial negotiations fail, it may be appropriate to involve ACAS. In the rare event a case goes beyond HR and into the legal realm, you should have a level of insurance cover. Ecclesiastical insurance provide this as part of their parish guard policy, covering any potential claims. A legal team should assist at this stage with the details of the issue and the claim.